My topic that I am going to discuss is the special groups of employees. Number 1 is the managerial and supervisory employees. Under Article 245, managerial employees are not eligible to join, assist, or form any labor organization. Supervisory employees shall not be eligible for membership in a labor organization of the rank and file employees but may join, assist, or form separate labor organizations of their own. Manager, one who is vested with the power or prerogative to lay down and execute management policies and or to hire, transfer, suspend, lay off, recall, discharge, assign, or discipline employees. The management policies must pertain exclusively to labor relations. Supervisor, one who, in the interest of the employer, effectively recommends managerial actions. Power to recommend must be both. Number 1, effective. Number 2, requires the use of independent judgment. Number 2 is the confidential employees. Confidential employees are also prohibited from forming, joining, or assisting any labor organization. Confidential employee is one who is entrusted with confidence on delicate matters or with custody, handling, or care and protection of the employer's property. Confidential employees may be managerial, supervisory, or even a rank-and-file employee. Purpose of disqualification of confidential employees. Doctrine of necessary implication. What is implied in a statute is as much part thereof as that which is expressed. Under Article 245, confidential employees are not prohibited from joining, assisting, or forming any labor organization. But by virtue of necessary implication, confidential employees are similarly disqualified. By the very nature of their functions, they assist and act in a confidential capacity to or have access to confidential matters of persons who exercise managerial functions in the field of labor relations. As such, the rationale behind the ineligibility of managerial employees to form, assist, or join a labor union equally applies to them. Access to confidential labor relations information. The information must be related labor relations matters. When the employee does not have access to confidential labor relations information, then the prohibition to form, join, or assist a union does not apply. If the access is merely incidental to his duties and not necessary in the performance of such duties, the access does not render the employee a confidential employee. Number 3 is the security guards. Under Republic Act 6715, they may now join a ABOR organization of the rank and file or that of the supervisory union, depending on their rank. Number 4 is the members of cooperatives. The member employees of petitioner or cooperative do not participate in the actual management of the cooperative does not make them eligible to form, assist, or join a labor organization purposes of collective bargaining. They cannot invoke the right to collective bargaining for certainly an owner cannot bargain with himself or his co-owners. Number 5 is the members of Iglesia Ni Cristo. The employee who should decide for himself whether he should join or not in an association, therefore, that the right to join a union includes the right to abstain from joining any union. The legal protection granted to such right to refrain from joining is withdrawn by operation of law, where a labor union and an employer have agreed on a closed shop. Number 6 is the government employees. The terms and conditions of employment of all government employees, including employees of government-owned and controlled corporations, shall be governed by the civil service law, rules, and regulations. Their salary shall be standardized by the National Assembly as provided for in the new Constitution. However, There shall be no reduction of existing wages, benefits, and other terms and conditions of employment being enjoyed by them at the time of the adoption of this code. Government employees not allowed to unionize. Number 1, members of the armed forces. Number 2, police officers or policemen. Number 3, firemen. Number 4, jail guards. High-level employees are also not allowed to join the organization of rank-and-file government employees. High-level employees, one whose functions are normally considered policy-determining, managerial, or one whose duties are highly confidential in nature. Number 7 is the employees of international organizations. Their objective is to avoid the danger and partiality and interference by the host country in their internal workings. The exercise of jurisdiction by the DOLE in these instances would defeat the very purpose of immunity, which is to shield the affairs of international organizations in accordance with international practice from political pressure or control by the host country to the prejudice of member states of the organization, and to ensure the unhampered performance of their functions.